Thank you. My name is Jack McGuire. I'm the Director of the Red Union Support Hub that provides services to a number of unions that I'm speaking on behalf of today. Over 17,000 workers are under attack under this bill. Hundreds of thousands of workers in Queensland are having their right to choose their representative taken away from them and their human rights stomped on. The NPAQ has over 10,000 members. The Teachers Professional Association of Queensland has over 3,500 members. The Professional Drivers Association of Australia has over 400 members. The Australian Medical Professional Society for Doctors has over 500 members. The Sworn Officers Professional Association of Australia has over 400 members. The Independent Workers Union of Australia has 1,500 members. This is the most anti-worker bill ever introduced into this parliament. And if any members here got elected off the back of the worker, they should be ashamed that a supposed Labor government would even draft this bill. It is steeped in cronyism. It is steeped in corruption. It makes a mockery of human rights. It makes a mockery of Gough Whitlam. What this bill hopes to do is shut down independent unions, unions that dissent against the government. It grants power to legacy unions to make an application that they are ineligible entities. An ineligible entity, ineligible for registration. The pathway to registration has been restricted and made impossible because our unions are incorporated associations and they have stopped that. Further to that, with the convenient right to belong rule, it would now mean that we have to either do a deal with the Queensland Nurses Union where they have coverage north of Brisbane and we've got everything south, or we have to make an application to deregister the Queensland Nurses Union, which we would never do because we respect the right of those nurses who are under the Queensland Nurses Union to stay with the Queensland Nurses Union. Further, it rips away protections previously given to industrial associations and leaves workers stranded. All we want is choice. If it then further gives a commissioner the power to grant ancillary orders, orders that our staff cannot represent members, office bearers cannot represent members, we cannot even arrange an agent to represent members, and we cannot hold out membership on the basis of saying that we can represent members in the QIRC. We have almost 1,000 matters listed before the QIRC right now. As we speak, we can and we do represent people in the Queensland Industrial Relations Commission. We support and fund the individual. Now, if we breach these orders, extraordinarily, not only just a hefty fine, but it forces the industrial registrar to write to the Office of Fair Trade to wind up the incorporation status of these unions, meaning that members become vulnerable to litigation threat. Wow. Even beyond that, it limits law-abiding associations and their members from updating their constitutions to say that they want to look after the interests of workers. But let's talk about the money, because that's what it's really about after all. Independent unions can run on $442 per annum. And we've proven that by existing for 8 years. Other unions charge double, but at least $250 per annum extra. With our Red Union members freely leaving legacy unions for whatever reason that they choose, that's $12 million per annum that no longer goes to the legacy unions and $4.5 million per annum that no longer benefits the ALP. It is also about limiting the choice of 110,000 nurses and teachers in Queensland from joining an outfit that won't force them to donate money or election support to the ALP. That's $27.5 million per annum that's being spent on ALP electioneering. Why is this government afraid of giving workers choice? Because this isn't about us or me or the NPAQ or the TPAQ. It is about vindictive coercion and punishing those nurses that dared to leave the Queensland Nurses Union and forcing them back into paying double to keep that ALP gravy train going. Corruption. Speaking of corruption, how's this? The long run-up to this bill started with a memorandum titled the Nurses Professional Association of Queensland, sent to every nurse in Queensland Health. It culminates in the line, the NPAQ cannot represent or advocate on behalf of an employee in relation to an employment matter. Now, rumours are that came out of the Deputy Premier's office, but I don't know that for sure. It was acknowledged as being misleading.
Well, we might keep to the facts then, in terms of you can't substantiate what you're making statements about.
I will. Thank you, Chair. It was acknowledged as being misleading during cross-examination in the Gilbert matter. It was drafted by Anne Garahy, Acting Director of Employment Relations. A few short years earlier, she was one of the highest paid solicitors at the Queensland Nurses Union. Then, the memo is cleared by legals. Afterwards, it's sent to the Queensland Nurses Union, who marks up changes and gives them back doesn't go past legals again, adopts the beefed up version of the memo, if you like. It's then sent out to a wider audience, meaning it was always intended simply to be a propaganda piece. In 1970, and my true concerns with this bill comes back to, in 1973, Prime Minister Whitlam signed us up to a number of ILO conventions, and they're mentioned at the beginning of the Act in Section 4, I believe. Principally, Convention 87, which says, Article 2, workers and employers without distinction whatsoever shall have the right to establish and subject only to the rules of the organisation concerned, join organisations of their own choosing without previous authorisation. Article 3, number 2, the public authorities shall refrain from any interference which would restrict the right or impede the lawful exercise thereof. Article 4, workers' organisations shall not be liable to be dissolved or suspended by administrative authority. And you might ask, what is a worker organisation? Well, Article 10 says, in this convention, the term organisation means any organisation of workers for furthering and defending the interests of workers and employers. And just to finish up, I'd like to quote a poem and give some commentary that some members may be familiar with. The Ballad of 1891. If Nordfeld and Gatling won't bring you to your knees, we'll find a law, the squatters said, that's made for times like these. The registered organisations could not kill us with litigation and lawfare. They could not coerce our members back into their organisation. So now they've come crawling to Parliament and drafted this bill. To trial in Rockhampton, the 14 men were brought. The judge had got his orders. The squatters own the court. We don't want standing. We do not want to bring matters on behalf of our members to the QIRC because, to be honest, it puts a target on their back and the commissioners will know who to give a black eye to. I honestly believe the Commission is packed with former registered organisation officials, the very same registered organisation officials that want to see us shut down. But for everyone that's sentenced, 10,000 won't forget when they jail a man for striking, it's a rich man's country yet. I will never stop trying to defend our members. I will never stop defending our unions. And if you do want to stop me, you better make it a crime.